A full bench of Supreme Court judges delivered the ruling on whether they can advise on when the next general election should be held.
We hereby order and direct as follows. We declare the Supreme Court has the jurisdiction to render an advisory opinion in the instant matter, but decline in the exercise of our discretion to give such an opinion with regard to the date of the next general election.
It was a mixed bag of results for Kilome Member of Parliament Harun Mwau, who had opposed the hearing of the election date petition before the Supreme Court, insisting it was only the High Court that could handle it. While the Supreme Court insisted it had the power, Mwau and Mugambi will still get their wish to have the High Court decide on the matter.
Responding to the High Court's request of 13th of October 2011 for directions, High Court petition numbers 123 of 2011, 65 of 2011, and 185 of 2011 shall be placed before the Constitutional and Human Rights Division of that court for hearing on priority and on day-to-day basis.
The petitions involve 4 petitioners, all seeking an interpretation of what the law says about the date of the first general election under the new constitution. Lawyer Mugambi Imanyara and Kilome MP Harun Mwau went to the High Court in March and in May, while the Interim Independent Electoral Commission and the Commission for the Implementation of the Constitution, CIC, went to the Supreme Court to seek a declaration of the election date. The High Court suspended the 2 cases in October to await the decision of the Supreme Court. Now the ball is back in the yard of the High Court, where it all began.
It has referred the matter back to the High Court for mention on 18th and to be heard on a priority basis.
The election date matter was also before Parliament, where some backbenchers opposed a constitutional amendment bill tabled by Minister Mutula Kilonzo. The bill seeks to change the election date to the 3rd Monday of December every 5th year from the 2nd Tuesday of August, as stipulated by the various clauses of the Supreme Law.
What the minister proposes, through his own words, is to clarify the Constitution. That is interpretation. That is not the function of the minister. That is the function of the judiciary as per the Constitution.
The reason why this was put in the Constitution was to avoid the mischief of any member bundling several amendments together in a way to mislead even people who would have opposed some amendment.
This house is created to make the law, and the courts interpret the law as it is. This court makes any law, and the courts will interpret it as made. So do not suggest that this house cannot make any law, even if the Chief Justice and the Supreme Court are sitting on this matter.
If the bill passes through the first reading, it will have to wait for 90 days to give opportunity for public participation before it can come to the House for second reading. Now, KTN Prime.